Namaste. I'm Dr. Suyash Chavan and I welcome you to this session organized by the Consulate General of India, Munich, to celebrate the Constitution Day of India. Did you know that the Constitution of India is the longest written constitution in the world? It forms the basis of success of democracy in India. The Constitution Day, or the Samvidhan Divas, is celebrated in India on 26th November every year to commemorate the adoption of the Constitution of India. It was on this day in 1949 that the Constituent Assembly adopted the Constitution, and the Constitution came into effect on January 26, 1950. It is also a mark of tribute to India's first Law Minister, Dr. Babasaheb Ambedkar, who played a pivotal role in drafting the Constitution of India. Today, we have with us lawyers and experts on the subject from Germany and India to discuss the similarities, the salient features, and the significance of the Constitution in the success of the two beacons of democracy, India and Germany. It's my pleasure to introduce Mr. Thomas Sase and Mr. Avi Mukhtar. Mr. Thomas Sase is a lawyer, partner, and an India expert at Corp Legal, a commercial law firm based in Munich. Mr. Sase advises multinational clients with a focus on trade and investment in Asia. And Mr. Avi Mukhtar from Indus Law is joining us from India. He is a founding member and senior partner of Indus Law and advises on variety of corporate, commercial, and foreign investment laws. Indus Law, founded in 2000, is an Indian law firm advising clients worldwide on Indian law in relation to their business strategies and resolution of disputes. Welcome, Mr. Sase and Mr. Dar. To begin with, let me request Mr. Sase to share his views on the principles of democracy and state in Germany and freedom, rights, and responsibilities enshrined in the German constitution. Mr. Sase.
Thank you very much, Dr. Chavan. It is a great honor to speak today to you on this day, the Constitution Day of India, and introduce a little bit of insight to the German Constitution. The German Constitution is a new constitution. It's dating to 1949, and at that time, the World War was just over, and the spirit of the German constitution makers was with the experience of the terrible experience of the World War II. So the intention was to avoid something like that happening again, to give the power to the people over the state, to allow freedom, to permit people to move around, to engage in professions, etc., to have property, and most importantly, to voice their own opinion. So if you look at the basic law, as we call it, the Constitution in Germany, there's one article on the principles of state. And it says the Federal Republic of Germany is a democratic and social federal state. All state power comes from the people. It is exercised by the people in elections and votes and by special organs of legislation, executive power, and jurisdiction. So, as it was, every law is and all actions of a government and jurisdictions are bound by the Constitution, and that means the law comes into existence by the legislation, which is the Parliament, and the second house, which is representative house of the regions. So every regional parliament has a representative in that house, and without the approval of the law that has been passed by the parliament, approval by the representative house of the regional governments, there is no law coming into place. In addition to that, there is a federal constitutional court in Germany, which can be called upon in case by anyone in Germany, by any person or any court who believes that constitutional law is being breached. So, and the judgment of the Constitutional Court can eliminate the existence or can make it void any law that that is determined to be in breach of constitution. So that's the balance of powers in Germany. Initially, as it were, the constitutional rights, the basic rights, when one can also say that includes, of course, human rights, are important in a relationship with the government and the jurisdiction, obviously. But they have also, according to the Constitutional Court in Germany, most recent cases have made that very obvious. Also, they have binding effect also to private entities. For example, private airports. There's a right of assembly on the property of airports when there was a big demonstration against the third tarmac that was planned in Frankfurt Airport. It was a big assembly, and that the Constitutional Court said this is okay. The Frankfurt Airport, private airport, has to endure this. Social media networks. Everyone has a right for their personal data to be removed. And the social media networks have the obligation to delete illegal content. So there you can see there's a direct implication from the Constitution on also private entities. So I will stop here. I don't want to give you a speech on constitutional law in Germany, but I would like to state, without giving away any information that Mr. Dar will give in a minute on the Constitution in India, coming to the values and coming to the most important points in terms of doing business. There's a property right. Everyone has a right to own property, but that property must be used in a socially acceptable way. And it can be taken away, the property can be taken away from the individuals or businesses for social and reasons, overarching reasons of the public. With compensation, of course, but it's possible. So there's no complete freedom, but there's entrepreneurial business support, and that is based on the freedom of own property, freedom of speech, freedom of doing business, freedom of exercising your profession anywhere you want, not only within Germany, but also within Europe. And I believe the similar values also exist in India. Thank you.
Thank you, Mr. Sase. Very important points mentioned there. Now I invite Mr. Nag to tell us about the salient features of the Indian Constitution and their significance.
Thank you, Dr. Chavan. So it's very interesting to hear Thomas talk about the background of how our constitution in Germany came about. The Indian Constitution is also a very new one. It came into force on 25th January 1950, and as Dr. Chavan mentioned, it was sometime in the making. Right after our independence on 15th August 1947, a very large constituent assembly was formed, and one of the challenges they faced was how to deal with the legacy of India's colonial past. So as Thomas mentioned, Germany was grappling with the past of the Second World War. India was grappling with the past of having a colonial power, the United Kingdom, having ruled over India. And indeed, there were nearly 600 different princely states all over India, scattered, some of them the size of a condominium complex, others the size of a European country. So multiple states And the principle in India was always under the British rule that there was a paramount power, which was the government of India, and it had its 9 provinces. And then there were hundreds of small princely states. And within the princely states, the rulers could create their own laws and carry on business. They could not do any external relations, but they could have their own police force, they could have their own taxation. But at the same time, partly because these states were so tiny, the paramount power, the government of India, always had the right to step in when they felt that there was some maladministration or there was something wrong which was going on internally in these states. And that was the challenge the founding fathers faced in India. As you know, a classic federal state such as the United States, there is a significant amount of respect for states' rights, whereas the India that we inherited in 1947 did not have that level of respect for states' rights. It was the principle of paramountcy of the union over the states. To some extent, this is reflected in our constitution. Our constitution has often been described by scholars as a very flexible constitution which creates a unitary model, but at the same time respects certain federal principles. The other thing which is fairly unique, and Dr. Jawan mentioned that it is an extremely long constitution. And this is partly because, unlike countries such as the United States, we did not have the benefit of being pioneers. So the Constituent Assembly and Dr. Ambedkar could not ignore the various precedents out there, the learnings of different nation states, the most recent nation state being Ireland, the Republic of Ireland, had very recently gained independence from the United Kingdom and formed itself into a republic. And some of this Irish appeal comes into our constitution, which has a slightly complex presidency where the president is indirectly elected. So, in a sense, unlike, say, the Queen of England, our president is not a person who is simply there purely as a nominee. He is indirectly elected by elected members of parliament and state legislatures. But at the same time, his powers are very similar to that of the Queen. He must always act under the advice of the cabinet, and he cannot simply do as he pleases. In fact, this is one of the conundrums of the Indian Constitution, that an elected president does not have any real powers at all. So the lessons of the government of India prior to 47, as well as the need to create a country which could act in a national interest, to bring together this entire patchwork quilt which represented India, went into our constitution making. And because of the nature of experiences which had happened in the 2 centuries of written constitutions, our constitution framers gave a very detailed exposition of what are the rights of the states, what are the rights of the union, and it gave out not just the basic features of the constitution, but also a working document which will actually help the Indian state to go forward.
Thank you, Mr. Dar, for the detailed explanation. There is no doubt that the Constitution plays a central role in ensuring the freedoms and rights of our citizens. I'd like to ask Mr. Sase. India and Germany, as you know, are important trading partners. And in this context, I would like to know the economic rights enshrined in the German Constitution and the role the Constitution plays in safeguarding and promoting business and trade.
Yeah, as I mentioned before, the economic rights are enshrined in the German Constitution as a part of the freedom of people to move around, to do business, and to voice their opinions. And from my experience, and I've been dealing with India since 1993, that is the same basic value also in India. The other values that I can see in common is the value of the family, the value of long-term relationships, which are very high up on the scale in both countries. So business and trade is very important for both countries, because both countries have a large-scale export business. And therefore, this freedom of doing the trading with other countries worldwide, and that's a long history, more in India than in Germany, actually, is very important. So if you remember what I said about the federal government and the regional governments, there are regional governments that that regulate regional matters. However, the federal laws have priority over regional laws. So that means certain federal laws, obviously, or all federal laws exist, are applicable in all over Germany, and only to a certain extent, federal laws are important, for example, for Indian investors or traders. So example is that if you do business in Munich, for example, that Munich municipality can exercise trade tax or for example building laws, etc., etc. So these type of laws would restrict you regionally. Otherwise, you can everything important to doing business is regulated by federal law. So we have a strong support also from the government to promote entrepreneurial activities in Germany. For example, startups and some high-tech businesses have access to cheap offices and support from the government through loans and subsidies, etc. So there's a lot of practical help also, and also regulations are in place to support that business. From a startup across all the different development stages of a business, and of course also protecting the property of anyone who is doing business with those businesses. So transparency and protection of property of counterparts is very important and also regulated by the law. And finally, as I said, from my perspective, there's a strong business sentiment between India and Germany. There is, however, a little bit a few to-dos on the information part. Why is it easy to do business in Germany? Some Indian investors always ask me, seems to be very complicated. Also, German investors ask me, India seems to be complicated. Actually, if you know how it's done, it's not complicated.
Very important point mentioned there. If you know how it's
one thing I wanted to just add to Thomas. Now, one of the very, although we started off by saying that Germany and India both have young constitutions, but I think it's very important that we bear in mind that the Germans may have had a new constitution, but their constitutional history really started with the reunification of Germany, if I may say so, in 1870. And the experience of Germany, and this is, I'm saying, not as an expert of German law, but it is a unique experience because the principle of social justice, which is enshrined in the Indian constitution in writing, was a philosophy which Germany embraced perhaps more robustly than other European countries in the late 19th century. So that is, for example, why you see this concept in Germany where the workers have significant rights. The right to form trade unions is respected. The management is supposed to deal with workers in a fair and reasonable manner. So in India, because we were coming out from the avarices of colonial free marketism, social justice had to be written or rewritten in our constitution, and that led to a lot of tussle of ideologies, especially in the 60s and in the 70s, where social justice was interpreted to mean to be a form of socialism. And indeed, in our preamble, we do say we are socialists, but that was irreconcilable to some extent with the principles of a mixed economy, where you needed free market principles. So this is reflected in some ways in the treatment we have to the right of property in India, which historically was a fundamental right in Article 19 of the Constitution, and then slid down to what is now Article 300, capital A, where the protection is there, but not as a fundamental right. It is simply a protection that the state cannot take away the property without having a valid law for it. And of course, a valid law will have to be a law which is fair, reasonable, and just. But I just wanted to mention that both countries are very pro business, if I may say so, in the constitutional scheme of things. Right to carry on trade and profession is indeed a fundamental right in India, and to that extent there is a significant similarity. However, India has a slightly more ideological enshrinement towards principles of social justice because of our terrible experiences of the past centuries prior to independence. Whereas in Germany, the great thing is that it was already in practice for perhaps 100 years before your constitution of 1949.
May I say something on that point?
Sure.
Please.
I think that's a very interesting way of looking at it, and I think there's definitely similarities in Germany, because the German economy is called social market economy. So it's enshrined in the definition of our economy. The economy has to be socially viable. That we can see and we can observe definitely right now during the pandemic, where people are maybe not able to pay their rents. So there's a cap made on the rents, for example, and where people are losing their jobs, and the state is helping with support and subsidies on that, and that's enshrined in the structure of employment law in Germany, which is again coming from the constitution as well. So the basic rights are in the constitution, and so always led by socially acceptable actions and also controllable. So if anyone comes into trouble or needs help from the state in the way of judgment, for example, from a court, the access to that government support is very important, not only for money, but also for clarity, for making to rule on any disputes. And that is also very highly up in Germany, and the disputes and the jurisdiction access is very, very important. So everyone who calls upon the court does not have to wait for a long time to get a judgment. So all that protects the individuals who are, by definition, the weaker parts of the state individually. But as a total people of the state, they have the power in their hands because they vote directly for the government.
Rightly said, Mr. Sasi and Mr. Dar. Yes, both the countries have a very strong business sentiment, a very pro-business environment, and so also they put a lot of emphasis on social justice. From what I understand from our discussion, India and Germany, both the countries have a federal structure, and it becomes important for the companies to deal with both the central government and the state government. They have to deal with the central laws and the state laws. And the constitutions, both in India and in Germany, have certain provisions that let this important provision not become a hindrance for trade and business. Would you like to add some more points on this, Mr. Dar and Mr. Sase, with regards to the federal structure and how this is not becoming a hindrance to the companies? Rather, it is empowering them and enabling a business-friendly environment.
Sure. So as I mentioned, India always had that one luxury that we did have in framing our constitution is that the starting point was the state which was very unitary in nature. So the India that we received in 1947 independence had a very unitary system where pretty much the government of India delegated its powers to the provinces that were there, and just turned like a blind eye towards what was going on in the Indian states, the princely states. So the powers which were there with the princely states were very residual in nature, and the powers of the provinces were completely controlled and directed by the government of India. So even though the Government of India Act of 1935 and the Constitution in 1950 tried to create a sense of federalism, this principle never went away. Now, it is true that only in an emergency, for instance, can the union government step in. And indeed, after the Supreme Court repeatedly laid down principles of the contours of such intervention, union governments are very wary of intervening with state affairs. It was also felt that principles of taxation were a hindrance to doing business. So India has dozens of states and union territories, and the feeling was that principles such as the sales tax, which was there, and the interstate sales, it was acting as a hindrance to interstate commerce. The difficulty was, as you know, the taxing power of the state was a very important way for them to provide for education, for providing for the basic necessities of the citizens. Just by the way, India does not have a concept of dual citizenship, where you do not, for example, if you're living in the state of Tamil Nadu, you are not a citizen of Tamil Nadu and a citizen of India, unlike, for instance, the United States. So, and even in taxation as it existed prior to goods and services tax, the income tax was always in the control of the union. So I do not have to pay a separate income tax in Delhi and then separate income tax to the union. And tax on manufacture, customs, these are all union items. And then the current government finally implemented something which a lot of governments were trying to do but failed to achieve, which was to bring in a goods and services tax, amend the constitution to enable this. And so today, a lot of simplification has happened. I think it is only possible because of our core belief that federalism is desirable, but it is not something written in stone. It is not as if, for instance, in Germany, that you had truly independent kingdoms coming together. So, in this sense, the German historical experience would have been, kingdom like the Kingdom of Bavaria, where you gentlemen are sitting, being a genuine independent kingdom and deciding to succeed. Whereas in India, princely states, even those with very large land areas such as Hyderabad or Jammu and Kashmir, ultimately did not have the power of foreign relations. They were always subordinated to the larger government of India. So in that sense, we have always been prepared in India to tweak that aspect of federalism, which is in the interest of business, which is in the interest of the overall citizenry of the country.
Mr. Sase?
Yeah, very quick one from my perspective. People believe, coming from outside, but also inside Germany, believe that the two states, the Free State of Bavaria and the Free State of Saxony, are actually different from everybody else in Germany. But that's not true because I don't want to teach you in history of German or German history, but it's important to know that these two states. Actually, when you say free state, they were freeing themselves from feudalism. In the case of Bavaria, 1919, actually by a communist saying that there's now a free state. Reason is that Germany didn't exist as it is today, until very recently in history. And every region had their own existence and powers. Reaching back to the Prussian and the Bavarian, Austrian, and Franken, France, and Roman Empire, etc. So we don't have to go way back in history. It's just 200 years, but this is where we came from. So basically, we couldn't take away the entire authority from the regional states, because it's also sensible to give authority to municipalities and regions because they know local matters much better than somebody in Berlin would know. And there is also, therefore, it's very reasonable to give them power to not only be liable towards their people and the local or regional environment, but also get the authority to set up the rules and regulations for that. At the same time, of course, there's an overall federal state, which means, as I said before, there are federal laws which are common in all over Germany, and the lawmaking is, as I said, done by two chambers. One is the parliament, one is the regional house. In the regional house, all representatives of the regional states are represented, and they will vote for or against every law that is being issued in the federal state. So, I don't want to get into politics. It depends on how the parties are, which party is actually ruling which country, which regional state, but it works pretty well. So everybody seems to be very happy in Germany about the structure.
I'm sure. Thank you, Mr. Dar and Mr. Sase. One of the beauties of the Constitution is that the Constitution has continuously adapted itself with the changing times through necessary amendments. And while doing so, the sanctity of the basic structure of the Constitution has been carefully maintained. So, Mr. Dar, could you throw some light on this and also tell us the role the Constitution has played to ensure the growth and stability of a diverse country like India?
Yeah, surely. But one of the interesting aspects of the Indian Constitution, which distinguishes it from a lot of other federal constitutions, is that the Indian Supreme Court is not just a constitutional court. It is not just a court which is, deciding on matters relating to the Constitution. It is not just a court which is deciding issues between states. So those are definitely two things that it does do, but it is also the supreme civil court of the country. So I could be fighting a case, for instance, in the Indian state of Uttar Pradesh, and the Allahabad High Court, if it decides on an issue even of Uttar Pradesh state law, that appeal I can bring to the Supreme Court. And that is, it is difficult to overstate the value of that over the last 70 years, because it has allowed this single court, the Supreme Court of India, to unify at least the interpretation of the multiple state laws which exist. Otherwise, you would have each state and its high court deciding its own interpretation, and you would periodically, as they do in the United States, you would have to sit down and try to harmonize the laws, make the amendments to make sure that each state is following the same law, because you could not do it judicially, because judicially each court would be supreme in its own state. So that is something which has really helped India in trying to ensure that there is a harmony in the legal system. Pretty much any lawyer you go to, you could say that maybe 80 to 85% of the laws are very similar, and that is always good for business. You obviously have some very interesting states with their own legacy, like Goa, for instance, which has a strong Portuguese law influence, especially in real estate and land development rights and law of inheritance. We also, by the way, in India have different personal laws. We have Muslim personal law, which is based on Sharia principles. We also have a different law for Christians and for Hindus. But the great thing is that it is the same set of public servants, the judges, both at High Court and Supreme Court level, who are entrusted with the interpretation of all these diverse law. Whether it's a Portuguese legacy law, whether it's Muslim personal law, it will ultimately be the High Courts and the Supreme Courts, the same judges looking at all of them. And that constitutional feature is probably something which has allowed India to solidify into a compact nation state over the last several decades.
Great. Thank you, Mr. Dar. The Constitution has indeed been instrumental in ensuring India's stability, strength, and success, as you have mentioned. And I think the Indian Constitution is very unique in its content and its spirit. Our forefathers drafted it considering the history, the diversity, the traditions, the characteristics which are very unique to our country. I'd like to thank Mr. Sase and Mr. Dhar for joining us. This was a very informative and insightful session. We wish fellow Indians back at home, in Germany, and across the globe a very happy Constitution Day. Thank you. Jai Hind.
Thank you very much. Jai Hind.
Thank you.